Chapter 6. Pre-trial motions. Pre-trial motions are the guidelines that are set to make a trial run smoothly and fairly for both sides. In a case like mine, there were plenty made by both sides. Many that you read in this chapter will be self-explanatory, and I will list them with little or no comment. Others will be highlighted to show the game playing that went on before the case came to trial. Stalling by the state and political manipulation by the judge in the interests of the state. Sam Amirani was the first to file, as soon as I was charged with one count of murder. On December 29th in Des Plaines, because of what they were finding at the house on Summerdale, he had petitioned the court for a psychiatric examination of the defendant, John Wayne Gacy. Then, because of the continued leaks coming from all the law enforcement offices, the Des Plaines Police, the county sheriff, and the state's attorney's office, he filed a motion for a protective gag order to silence the speculations and rumors escaping from the investigations. The strategy in the leaks was to release so much adverse publicity that it would be believed that they had me called in red-handed. The more certain the conviction, the less criticism the public would level at the police work. The court order read, in general, that no persons in the state's attorney's office, the Cook County Medical Examiner's office, or any employee of the Des Plaines Police should give public statements of matters which should be prejudicial to the defendant's right to a fair and impartial trial. In short, nothing about the case should be given to the news media about anyone in custody. But those offices continued to release information that was favorable to them and destructive to my defense team. On January 10th, 1979, mention of this court order was reiterated in court by Amirani because of some of the investigative offices had contemptuously paid it no heed. The court glossed it over, shrugged its shoulders, and proceeded. After the indictments for 7 counts of murder were read at the arraignment, Amirani came back with his first of many motions of the day, that being to quash the indictments. He based his motion on the grounds that no competent evidence was being heard before the grand jury, that the state did not call any of the eyewitnesses who may or may not have been in a position to identify the defendant herein, and relied on the hearsay statements of a police investigator who was not present at the occurrence which is the subject matter of this indictment. That without notice to the defendant or his attorneys, defendant was indicted without a preliminary hearing. Following this came a motion of discovery, asking that the state be directed to furnish to the defense copies of all material it intended to use against me. The state responded by requesting discovery from the defense. One of the big issues which will come out during the case, pre-trial, all the way through the trial, was the unusual and illegal way the Fourth Amendment was abused to satisfy the needs of the state. He asked the prosecution to produce and preserve all search warrants and complaints for search warrants. I had been in jail 19 days, and still not one warrant had been served on me. Not one warrant had been posted on the premises, and no cause had been given to show why the warrants had been issued, or how many had been. As they cannot be produced or proof shown that they were even issued, the search was illegal under Illinois laws. The rules were perfectly clear as to search warrant procedures, yet, for some reason, all the rules were thrown out the window in this case. Amirani knew that the search warrants were erroneous and therefore illegal. Amirani protested that he had been refused admission to the property, although he had the right to protect the interests of the defendant, his personal property, and the real estate owned jointly by his family. Because the search warrants had not been produced, he motioned the court for a cease and desist order, stopping all work at the house until the state could prove it had valid search warrants and had shown cause for the issuance of such warrants. Attorney Mata, in another motion, asked for the return of my motor vehicles. There was no reason to be holding the 3 vehicles unless the state could show a preponderance of evidence that such vehicles were used in the commission for a criminal offense. The state refused to return them even though they had been finally combed and cleared. Perhaps they were afraid I might sell them to raise money for my defense. I could think of no other reason. One of the vehicles, a pickup truck with a snowplow, was being used illegally by employees of the county to plow parking lots, making money for their personal use. They disconnected the odometer and left it disconnected. It was still disconnected when it was finally returned to Amirani and Mata. Another motion filed that day was to compel the prosecution to disclose whether it would request the death penalty. The prosecution averred that it should not be compelled at that time to answer it. It would only say that if it got a conviction, it would then seek that penalty. The state's attorney's office was the bailiwick of politician Bernard Carey, who was at that time in his push for re-election and who knew the favorable public impression that could be made by a death penalty announcement. As throughout the trial, the convenient brotherhood of politics and law reared its powerful head. On January 30th, my next court date, the state moved to extend the exploration and excavation of the Summerdale property, contending that there had been 5 search warrants issued and voicing a remonstration to the cease and desist motion. Amirani protested that Judge Garippo had not yet ruled on the motions of January 10th and that to allow them to go further would be to grant them a fishing license. He demanded to be shown by evidence why the court would justify any continuance of the search, that they were already outside the bounds of the original warrants. Garippo tried straddling the fence and wouldn't address the issue, claiming it was all too confusing. Finally, he took refuge in the weather, saying, "I think that in the view of the fact that the weather is so bad anyway, I don't think much work can be done in the next few days. So before I would sign this order for further exploration, I might as well litigate quickly the issue of the search warrants. Because if the search warrants would be invalid, I would be extending an invalid search warrant." Transcripts, pages 68 to 69. Judge Garippo set a hearing for February 16th so he could start ruling on some of the motions that had been filed. So on that date, the first of many hearings were held for motions prior to the trial. 2 issues of the day were the matters of illegal arrest and the questionable search warrants. Amirani wanted both issues dealt with so as to create a chronology and a sequential order for the trial. The first search warrant was issued before my arrest, and the second while they were holding me at the station on the drug charge. The first officer called as a witness was a member of the surveillance team. Amirani used them to show that Des Plaines and Niles, where the arrest took place, were not adjoining communities and therefore officers were out of their jurisdiction. His other purpose was to show the illegality of the marijuana charge. I had no marijuana on my person at the time of the arrest, none in my vehicle, and was not observed by police to have rid from my person anything resembling marijuana. But in cross-examination, the officer claimed that, earlier that day, he had seen me pass to another person what he believed to be marijuana cigarettes in a plastic bag. That, following my departure from the gas station, he recovered the bag from the owner, who said that I had given it to his employee. So the officer wasn't sure that it came from me, nor was it tested prior to my arrest. Actually, they didn't know at the time of my arrest if it was marijuana. Upon redirect questioning, Emirani wanted to know why the officer waited 3 hours before making the arrest, and why there wasn't an arrest warrant obtained during that time. Since the officer was assigned to the Des Plaines Police Department and the arrest was made in Park Ridge, were the Park Ridge police notified? No. Did they take me to a station in the district I was arrested in? No. The officer stated that he had followed me from the municipal limits of Park Ridge into Norwood Park, through Norridge, on into Chicago, making a stop in each municipality, even talking to me before stopping me in Niles. When in hot pursuit of a culprit, the police have the right to pass from one jurisdiction into another. The officer admitted that he was not in hot pursuit, that Gacy was not fleeing or eluding. Garippo ruled that it was not hot pursuit. Emirani made the point. So, they didn't have the jurisdiction, since it was not hot pursuit. Emirani went over the officer's log, which stated that I was picked up at 12:15 p.m., and although we're never formally charged with possession, I was at 10:30 p.m. charged with murder. He pointed out that I was not charged with murder until the following morning, so in fact I was kidnapped and forcefully and illegally detained. Transcript, pages 85 to 137. The next witness was Greg Bedeau, investigator with the Cook County Sheriff's Department. Emirani quickly established that Bedeau had never investigated any person other than me in the disappearance of the Peast Boy. It was affirmed that no other subject existed in his mind from the first moment he suspected me until the moment of my arrest, that he directed an investigation without a shred of evidence linking me to a crime. Emirani was able to get Bedeau to testify that his office was responsible for my arrest and, more important, that I had been detained for 13 and a half hours until they could obtain a warrant for my arrest. Emirani then reminded the court that there were three things that had to be decided. First, whether there was any authority to arrest, which he doubted. Second, whether there was probable cause for the arrest. Certainly nothing pressing, since the action wasn't taken for 3 hours. And third, that legal process was ignored and that the detention was for the purpose of putting undue pressure on me. For the arrest to have been legal, I should have been brought to the Niles Police Department, where the arrest was made, or to the Park Ridge Police Department in the district where the offense, the transfer of marijuana, took place. The third witness to be called was another officer from the surveillance team. He testified that on the night of December 19th, he went to my house to use the bathroom, and while there noticed a foul odor hanging in the air. When the heating unit clicked on, the odor became more distinct and putrid. The state's attorney guided the officer to say that the odor was similar to that of a decomposing body. He had been on the police force 8 years, and in that time had been in the presence of more than 40 bodies that were in a state of decomposition. The smell was the same. In cross-examination, Emirani attacked the officer's self-proclaimed talent for identifying the nature and source of scents. He asked the officer why, if he was so certain on his talent, did he postpone relating this powerful information to his superiors for the next 40 hours. Continuing his attack on the officer's ability to detect that kind of odor, Emirani asked, "You know that there are things that smell similar to putrefied human bodies. Is that correct?" "That's correct." "Among those would be the decaying vegetables, for instance. Is that correct?" The witness answered, "I would imagine, under certain circumstances." "Among those things that would be decaying non-human animal bodies. Is that correct?" "Correct." "Among those things would be feces, either human or animal. Is that correct?" Again he answered, correct. Transcripts, pages 211 to 212. Amirani readdressed the court on the issue to squash the arrest and the tainted second search warrant. He brought the facts to light. There is absolutely no testimony showing that Mr. Gacy was attempting to avoid arrest, and there was no hot pursuit. That is the statutes of the law in Illinois. It's statutory, Judge. Chapter 24, Sections 747 and 748. Section 7 to 47 defines a police district. A police district is the territory which is embraced within the corporate limits of adjoining municipalities. Pretrial transcript, page 18. He then pointed out the results of the testimony of witnesses. The point is that the arrest, and it was brought out by Officer Badeau in the extensive cross-examination of the state, it was a subterfuge, a ploy, a pretext to get Mr. Gacy in custody in hopes that something would be found. With all the information that was collected, allegedly collected, because we don't have it in the complaints for the warrants. No request was made for arrest warrants. A second search warrant had not been prepared and was issued only after Mr. Gacy was in custody for 7 hours. Amirani compared this to the classic case of Brown versus Illinois in the U.S. Supreme Court, cited at 422 U.S. 590, which came up in 1975 after a murder conviction. Brown was arrested by Chicago police without a warrant for the purpose of conducting another investigation. While being detained, he waived his Miranda rights and voluntarily gave statements when confronted with items found during a search. This case, too, was one of illegal detention. The matter of the Miranda rights was immaterial, because the issue in that case, as well as mine, was not the Sixth Amendment violation, but the violation of the Fourth Amendment, unreasonable search and seizure. That's what Amirani was now questioning. Brown was found guilty, but later, by an 8-0 decision, the Supreme Court reversed the verdict. Amirani: to make an arrest without an authority is certainly unreasonable. The arrest was a sham, and according to the High Court, you cannot profit from your own wrong. That to violate the man's constitutional rights is no better than violating the law. When Amirani finished, William Kunkel argued for the state that the one had nothing to do with the other, that nothing was gained by the arrest to render it dismissible or to allow the defense to squash the search warrant. And even if it had been illegal, they had plenty of ground to arrest me, maybe even earlier than they did. The judge gave Amirani a chance to respond and clear up a few questions for the court, but my attorney's lack of experience and background in criminal law left him nonplussed. Garippo asked, "Do you have a case of a police officer's district, if it's an otherwise legal arrest, was made out of his district by a police officer of this state, would give to suppression of evidence?" Amirani responded, "No, Your Honor, not specifically." Garippo gave Amirani several chances to help the court make a decision in support of what Amirani had said during the hearing, but Sam couldn't follow through. So Judge Garippo stated, "The motion is entitled, the motion to quash, arrest, and suppress evidence. I have always stated that there is no motion in law as a motion to quash arrest." The court only makes a determination as to the validity of the arrest when the court has to determine whether or not evidence seized as a result of unlawful arrest is subject to suppression. Pretrial transcripts, page 253. So, my even assuming at the worst for the state that the arrest was illegal under Brown, the court has to make a determination as to the connection between the arrest and the actual taking of the statement. So the motion to quash arrest, which I don't think there is such a motion. It is commonly filed, but I have always stated there is no such a motion. But I make a finding that there is no showing that the arrest of John Gacy at 12:15 is in any way connected with his statement some 13 hours later, in the presence of an attorney and against the advice of his attorney. So the motion to suppress evidence will be denied. Pretrial transcripts, page 254 to 256. He then set over his ruling on the search warrant until February 21st, 1979. The hearing that day had lasted until almost 5 o'clock. You could feel the tentativeness in the courtroom. There was fear of the unknown terrain and the danger that an indiscreet move might cause, and no one wanted to make an unretractable error. The law was playing second fiddle to the pressure of the ever-present news people, the political pressure on those involved who had re-election to deal with, worrying about the public whose rancorous feelings were the result of, and being fed by, the media. And, like the politician he was, the judge equivocated throughout the trial. Never did he show the precision and clean-cut language one expects of a jurist. He claimed that there was no such motion. There was no motion such as Emirani raised, quashing of the arrest, yet it continued to be allowed during the hearing. I had asked for F. Lee Bailey as a counselor, and the need was now evident. The lack of experience of Emirani and Mata, both young and newly out of the public defender's office, having only 5 years of experience, was showing. My case was of a magnitude that could have proven awesome to any lawyer in the country. It was a unique case, and its technical difficulties were redoubled by the centripetal pressures of media brainwashed public, the media itself, and concerned politicians. On February 21st at 11:50 a.m., the hearing was called to order by Judge Garippo. The motion before the court dealt with quashing the search warrant on December 13th, the 2nd of December 21st, the 3rd and 4th of the 22nd, and a 5th issued on December 29th. The reason for introducing all 5 together was that the ruling was going to affect all 5. If the first or second one fell, the rest would fall by domino theory. Mr. Mata would attack the face of the warrants, then what is called the 4 corners of each. In his opening remarks, Mata said, "I believe that the law is clear, Your Honor, with respect to the person and the place to be described. There is the requirement that the person to be searched and the place to be searched be described with particularity and specificity. The description must be so specific, in fact, so accurate, as to avoid any unnecessary or unauthorized invasion of the right of security. It should identify the premises so accurately that it leaves no discretion whatsoever to the police officer. The first corner of a search warrant regards the person. The warrant of the 13th stated that John Wayne Gacy was to be searched, but have nothing in the way of description of the person. Point 1 ignored by the police. The second corner of a warrant regards the place. That search warrant gave an incorrect address, namely Norridge, Illinois, rather than Norwood Park Township. This mistake alone should have invalidated the warrant. The third corner of a warrant regards the naming and description of any items to be seized. Quoting from the warrant: light blue down jacket with hood, tan covered Levi pants, brown wedge type suede shoes, lace type, brown leather wallet, Levi t-shirt, along with hair samples, blood-stained clothing, dry blood sample along with 3 vehicles, which list them one by one. Pretrial transcripts, page 268. Mata tore that apart by saying that if you're going to a home where only male persons live, what else would you find besides male clothing? The descriptions of the property to be seized were not sufficiently detailed. It didn't state who the jacket belonged to or even the size. No mention was made of the kind of material or if it was zipper or button down. The inadequate description could have fit those belongings to any number of people who frequented my house. Brown leather wallet. Half the men in Chicago carry a brown leather wallet. There was not even a caution to look for identification in such a wallet. T-shirt, Levi pants. Again, there was no way to tell from the warrant who these items might belong to, had such been found. Hair samples. Whose hair? What color? What length? As far as the warrant concerned itself, it could have been my hair they would seize. The effect of the warrant was to give the police a fishing license. According to their inventory, they had seized 39 items from the house, none of which were listed on the warrant. This is known as a legal search and seizure. The fourth corner of a search warrant concerns probable cause. The complaint for a warrant must show probable cause that certain evidence is going to be found where an informant says it is. In this case, a reason to believe that Robert Peast would be found at my house. Such could not have been shown in the complaint for this warrant. No one could have put the two of us together. We were not seen conversing, near each other or even in the same area after Peast walked out of the drugstore. Nor did we talk to each other in the store regarding work. It was pure speculation that since he left the store to talk with a prospective employer, that man had to be me. Robert Peast never said that he was going to talk to John Gacy, nor did anyone see us talking together outside the store. Total speculation, Mata told the court. Those were simple, uncomplicated facts. The state defended every corner of the warrant. Kunkel claimed that he didn't think it necessary to give any more detailed description to the blue jacket, and he felt that the general items listed on the warrant were inadequate. Concerning the items seized but not listed on the warrant, he used the clause from the rule of plain view evidence. The attorney cited court cases relevant to their respective stands. Amirani again claimed it amounted to a fishing expedition, a general search in the sort prohibited by all the courts in the land. He said a search warrant can't be general in its descriptions, that it must state specifically what it sought and where it will be found. He closed his day's presentation on that note.